is Tom Fox, and I'd like to welcome you to episode 239 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. Today I have back with me my good friend and colleague Jonathan Armstrong from Cordery Compliance, a UK-based law firm. Jonathan is a well-known data privacy expert and compliance expert as well, but today he visits with us about the new EU Privacy Shield, which takes the place of the safe harbor provision invalidated by the Schrems decision last year. Jonathan goes through the negotiations, talks about some of the pitfalls and traps for U.S. companies, and then ends with a discussion about the member companies and their potential roadblocks. The episode comes in at just over 22 minutes. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I have back with me my good friend Jonathan Armstrong. Jonathan is a partner at the Cordery Law Firm in the United Kingdom, and there's been a lot of information, news, and frankly, some excitement, I would say, about what's going on with the EU and data protection. So I asked Jonathan, a noted data protection specialist, attorney specialist, if he might come on and visit with us and share what's going on, what's happened, what it might mean for U.S. companies going forward, and what they need to do. So with that somewhat long-winded introduction, Jonathan, thank you for visiting with us today.
My pleasure, Tom, and thanks for the invite.
Jonathan, I think that probably the biggest news was that it looked like the EU was able to reach agreement with American negotiators over some type of new data privacy protection. And maybe you could kind of take it from there.
Yeah, I mean, the honest answer is, as far as the replacement for safe harbor is concerned, as we sit here at the moment, I must say I'm deeply skeptical. As a recap, obviously, Tom, you and I spoke about this before, but the safe harbor deal, if you like, the transfer data between Europe and the US died on the 6th of October. There's been an attempt to have a child of safe harbor, known by the catchy title of Privacy Shield, and that's been in the offing since the beginning of February. And we had this torrential pace of change at the beginning of February. Originally, the influential Article 29 Working Party said that basically the Commission had to come up with a Plan B by the end of January. The Commission failed to do that, but on the first Monday in February, the Commission went before an influential European Parliament committee and said that they had the makings of a deal with the US. That was firmed up with Penny Pritzker on the Monday evening. On Tuesday, the European Commission had a press conference saying that they'd got this new deal. And then on Wednesday, they went before the Article 29 committee and said that they'd got a deal with the US. And quite rightly, I think, the Article 29 committee asked what that deal was. And that, I'm afraid, is where the detail has ended.
Right.
Equally, the White House had an open house session on Twitter on that Wednesday evening our time, but it's fair to say that didn't illuminate much either. So we know there's the makings of a deal, but I guess we'd say as lawyers that it's at best heads of terms at this stage. It has a catchy name, but in my view, very little else.
Well, let's explore son of data protection then, or child of data protection, or child of safe harbor, I think was your phrase.
Yeah.
So what have they agreed to going forward?
Well, they've agreed that in some respects there'll be an executive memo. I'm not using the right terms, obviously, but it seems that there's going to be some executive memo from President Obama to the arms of the US administration, telling them to respect Europeans' privacy rights. Now, that's obviously in some respects to be welcomed, but one wonders, if that will be something that President Trump, for example, I'm teasing you, Tom, will maintain in January. It's obviously only going to be a short-term deal, I guess, because your administration is going to change. Secondly, there is a recycling of an arbitration scheme that already exists for individuals to have redress. This has been presented as something bright, shiny and new, but I think has existed since the original Safe Harbour deal. There is a subtle difference that those individuals who wish to complain using new arbitration won't have to pay, whereas currently under some schemes they do have to make a contribution. There's new US legislation, the Judicial Redress Act, although some say that that legislation has been watered down even since the version that Commissioner Jourova spoke about at this first Monday in February meeting. And there's some further supervision promised from the US authorities. It remains to be seen what exactly the detail behind that is, particularly because theoretically at least the US Department of Commerce and the FTC have had oversight of the existing Safe Harbour scheme. So as we sit here, it's hard to see what's so dramatically different that Privacy Shield, that would make Privacy Shield survive a court challenge. And there's just two other things maybe to mention, Tom. First of all, as I said, the regulators remain somewhat unconvinced. They've asked the Commission to come back before the end of February with some meat on the bones, if you like. What exactly is the deal and what does it mean in terms of protection? And secondly, the Article 29 Committee said, we gave this enforcement deadline at the end of January. Privacy Shield might be the son, but it's, if you like, a pregnancy rather than a birth. And so we're not going to suspend the previously promised enforcement action. And indeed, we've seen the French authorities, and we believe, we're waiting for details, two of the German regulatory authorities already start enforcement proceedings, saying that US corporations that rely on Safe Harbour are unwise and open to prosecution. And we believe that there are active complaints in Germany, in the UK, in Ireland, in France, and in Belgium, which will all have to be investigated, I think, by the regulators in those countries.
So if we can continue our cross-mixing of metaphors, perhaps the one I would like to throw out is it's time to let your freak flag fly, because it occurs to me in both what I've read and what you've just said is the Commission may or may not give us something in writing, but it's the regulatory bodies who are going to have the final say on this. And even if it's a majority of regulatory bodies, still there could be a minority who would object, and U.S. companies would be subject to sanctions from any specific regulatory body in an EU member country.
Yes, that's exactly right. And I think the most challenges we've seen so far, or that we know about publicly, are from authorities in Germany. And bear in mind, as we said, I think last time, the German system is state by state, not federal. And so it is entirely possible that we'd get some regulatory authorities in Germany agreeing to suspend enforcement action, but not others. And one thing we know from the original Schrems case before the European Court is that individual regulators have more power to decide stuff on an individual basis. So we can expect some discrepancies, I think. There's some attempt at uniformity with this Article 29 committee, but obviously most of the regulators are saying we're going to be complaint-led to a large extent. So if we receive complaints from people, we're duty-bound to investigate them. Why? Because the Schrems case says we have to.
So in one of the things that your firm is very, very good at is providing information on your website, providing information in the form of client alerts or other memoranda that you might circulate for people like me to read. And in your memorandum of, or news item, perhaps I should call it, of February 15th, you say that the action plan has 4 priorities for the Data Protection Board. Could you maybe go through those priorities and explain what they mean?
Yes, absolutely, and thanks for the kind comment on the note. So, as well as this large debate over Schrems and Safe Harbor and Privacy Shield, there's also a debate over some new legislation that will apply across Europe. This is called the GDPR, the General Data Protection Regulation. And this is a new law that will come in probably sometime in 2018 and is in the process of being formalized. This also has a huge impact on things like internal investigations, regulatory inquiries, e-discovery, and so on and so on. Partly because it increases the penalties for getting things wrong, up to 4% of global annual turnover. Partly because it makes things like consent much tougher. So many organizations will take consent from people in an internal investigation to transfer their data. Partly because its territorial reach is extended. So US organizations come within the European rules. So even a firm of US attorneys, for example, that didn't have any presence in Europe but was doing an investigation here would be subject to European law much more easily prosecuted. And I guess fourthly, with something called the right to be forgotten, which is a significant piece of legislation in itself. And what it basically says is that individuals have the right to ask for data on them to be erased. Again, very challenging in an arena like internal investigations, where an individual could say, I withdraw my consent to any data on me being handled, and I demand the right to be forgotten. I demand that that data is erased. And we've already seen some judge-led law on the right to be forgotten that has led to some very nasty people trying to erase history so that they don't appear on, or so that they appear as good guys on due diligence searches, to fraught anti-money laundering investigations, and so on and so on. And it's that piece of legislation that Article 29 Working Party is setting their agenda for. And they're saying that this legislation is going to take about 2 years to come in, so we need to prioritize our actions. And the Article 29 Working Party is going to set out an agenda for what they think are the most important things. It's fair to say that the Article 29 Working Party will also be replaced by this new legislation with a tougher body that will have more power. Currently, Article 29 only has a sort of advisory role, although its advice is persuasive to other regulators, and that will change under the new regime as well. So it will be significant because we can assume that any paper that Article 29 publishes on the new regulation will be adopted by this new body that will have more teeth in 2 years' time. So I think we are going through a significant sea change in terms of data privacy law in Europe, and this is just one aspect of it.
So what are some of the things that a U.S. company either could or should be doing now to help prepare for any of this, other than, of course, calling you, getting your good counsel?
Well, that's always a good idea. I think, with both developments, both Safe Harbor and with GDPR, planning is key, really. I don't think with the Safe Harbor scheme, because it went overnight, none of the regulators particularly expect the business to have a long-term solution, but they do expect them to have a plan in place to move towards a solution. It's the same, I think, with GDPR, and we're seeing at the moment preempting of this new regulation. So in the Netherlands, for example, they've introduced some bits of the regulation early, which they did in just January this year. And we're also seeing the French authorities saying that things like the 4% maximum penalty will be introduced by French domestic legislation earlier than 2018. So now's the time to plan. I think there will be all sorts of things to do. The first concentration is going to be vendors. So So if you're doing something like an internal investigation, look very closely at e-discovery vendors, for example. Some of them are plainly better than others, and you're going to be responsible for them. If you're the commissioning attorney and the contract is with you, then you're likely to have to supervise what they do and how they do it. So there's a big piece of work to do around due diligence on vendors. There are pieces of work to do around looking at consent, how you actually legitimize data transfers now that safe harbor's gone. How do you, if you're an attorney running an investigation, how do you get some comfort from your client that the investigation is going to be handled lawfully, and so on and so on. And I think the real challenge is looking at things like the right to be forgotten. We don't have the fine detail on this yet, but for many organizations, attorneys included, they're going to need to have a proper procedure in place that deals with these requests, because the time for dealing with requests shortens as well. So there's another right called a subject access request, where an individual can say, what data do you have on me? We've only got a month to reply to those requests. So we have to have a proper procedure in place to know what they look like, how to recognize them, and how to deal with them quickly.
Jonathan, one of the things that I think concerns American companies the most, or at least perhaps in the compliance space, is around this issue of consent. And we previously visited about some of your thoughts on what at least in the States we've called informed consent, where you actually have to inform people of the consequences of their consent. And you specified with great detail what you thought might be informed consent. But what I wanted to ask is that type of, could you put consent in an employment contract? Do you have to put consent in front of an employee immediately before an investigation? Do you have any thoughts on how an American lawyer or an American company might think through some of those issues around the consent issue?
I think it's a very, very challenging situation. I think the simple answer to the first question is it's unlikely to help if it's in an employment contract. I think most people will try and put it there anyway, but certainly in some jurisdictions in Europe, it won't help. Why won't it help? Because the jurisprudence is around almost the master-slave relationship. So if you've given somebody a contract and you've made them waive their rights to object, then that's akin to slavery. And even if you do get consent in the contract and it's valid, consent can be withdrawn. So you quite often see this in an internal investigation, particularly where the suspect lawyers up and you get a letter from the lawyers representing the suspect to say, and by the way, consent to data transfer is now withdrawn. So that puts you in a very difficult situation. In some cases, of course, there are exemptions to data protection rights and investigating criminal offences where it's necessary to do so can be another limb that you can rely on. But consent is challenging, and I think the reality is that in most cases you will have to at least give notification and probably give or probably ask for consent to a suspect in an investigation. And sometimes that can be challenging. I've done interviews where we've spent maybe the first 30, 35 minutes, 40 minutes of an interview discussing consent. As we said before, we have to give, for consent to be valid, it has to be full and informed. So you have to say exactly what you're going to do with the data. In some cases, I've seen that there's a negotiation either with the interviewee or his or her lawyer who will say, yes, I'll consent if you do X and Y or you make these promises to me. And in most cases, of course, you can't make those promises. You can't agree to conditions on the interview, particularly if it's something that you may wish to turn over to the authorities. So that whole area, I think, is challenging. And I guess, and I would say this, wouldn't I, Tom? It means that any team that's doing interviews in an internal investigation really does need to have a first-rate privacy lawyer in the team. You are going to need to answer questions particularly if you're a U.S. attorney coming into Europe, you are going to need to answer questions on these difficult areas. And it isn't a place for the enthusiastic amateur, particularly when suspects in investigations are relying on their data privacy rights to thwart, to end an investigation. And almost why wouldn't they? If you're somebody who's been caught with your hands in the till, why wouldn't you take every opportunity you can to get away with it? And unfortunately, a lawyer who doesn't know his way around the data privacy rules, it provides an escape chute for a suspect in an investigation.
Well, Jonathan, it seems that we will need to continue this conversation as the thought and written product from the Commission and the EU Commission evolves, and there's continued commentary from the regulatory authorities in not only each country, but in some countries in each province.
I think that's exactly right. The aim is that we have more uniformity in the law with the passing of the GDPR. It remains to be seen whether that will actually happen in practice, I think.
Jonathan, that seems like a great point that we would end on. But before we do end, I was wondering if someone wanted to follow up with you on any of the points you have raised. Could they contact you? And if so, how would they do it?
Yeah, sure. Happy to. Jonathan.Armstrong@corderycompliance.com, CORDERYCOMPLIANCE.com. I always realize when I read it out that our URL is probably too long. You can use the same URL to read the articles that you were so kind about, Tom, and I thank you again for that. If it's non-confidential, of course, you can reach out via Twitter @ArmstrongJT. LinkedIn works. We also receive racing pigeons, so contact us any way you will.
And I would just say, from certainly my perspective in studying this and listening to you and others talk, it is becoming increasingly more complex, and the need for really studious or studied counsel who can help you navigate this is becoming increasingly important, in conjunction with, here in the United States, the Department of Justice's stated goal of prosecuting more individuals more aggressively for not only the FCPA, but indeed all white-collar crimes. So it's an area, a minefield, really, that people need to tread carefully, and I hope that they will take you up on your kind offer to contact them, and you allow myself and you to continue this conversation.
Yeah, I'd welcome that. And thanks again, Tom, for the opportunity. Do a
All right,
job.
we will continue the conversation. Thank you.
Thank you, Bano.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have 2 calls to action for you. The first is if you could rate this podcast in iTunes, I would greatly appreciate it. The second is if you would leave a comment or question. I'm developing my next mailbag episode, and I'd love to answer your question on an upcoming episode. So email me, or you can leave a comment on the comments section on this podcast site. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance and Ethics Report.